Today we are going to be looking at the area of contract law. In the common law, a contract can be compared to a form of private law whereby the signatories to an agreement undertake to carry out acts or duties in anticipation of receiving a benefit. A contract can be distinguished from a simple agreement between friends by the fact that it is enforceable in law, and a failure by one party to respect the terms of the contract will give the other party to the agreement a right of action before the courts. So what are the ingredients necessary for the formation of a contract? Under the common law, 4 basic requirements must be met in order for a contract to come into effect. There must exist 1. An offer made by the offeror, 2. Acceptance of the offer by the offeree, 3. Consideration provided by both parties, i.e. some kind of payment or exchange of value between them, and 4. An intention to create legal relations, i.e. proof that the parties intended to enter into a legally binding contract. So what is an offer? The first requirement for the formation of a contract in the common law is the existence of an offer made by the offeror to the offeree. An offer must be distinguished from an invitation to treat. An invitation to treat is merely an indication by one party that they are interested in doing business with the other party, but it falls short of being an actual offer. Often this is because it lacks sufficient detail to allow real acceptance by the offeree. For example, if X, who has 3 cars, offers to sell Y his car without specifying which of the 3 cars he is referring to, it will be impossible for Y to accept this offer, as Y does not have enough information for real acceptance to take place. In a case such as this, X will be said to have made an invitation to treat. For example, a call for tender is normally classified as an invitation to treat. Thus, the party replying to the tender will be considered to have made an offer, which may then be accepted by the party that issued the tender. It is important to remember that there is no hard and fast rule distinguishing an offer from an invitation to treat, and each situation is decided on its facts. For example, it is a general rule of the common law that an advertisement offering something for sale is not an offer, but merely an invitation to treat. However, an advertisement may be construed as an offer where there is sufficient certainty and detail in the advertisement. In distinguishing between an offer and an invitation to treat, the courts look to the facts of each case and apply an objective test, asking themselves what a reasonable person would consider to have occurred, i.e., whether an offer or an invitation to treat has been made. Where the transaction is occurring between professionals, normal industry practice will be a significant factor, i.e. what people in the relevant industry would consider appropriate behaviour. An offer may be withdrawn by the offeror at any time prior to acceptance by the offeree. However, the revocation of the offer must be communicated to the offeree. If not, then the offer will remain operative, i.e. in effect. Now let's look at acceptance. Once an offer is made by the offeror to the offeree, there must be clear and unqualified acceptance of the offer by the offeree if a contract is to come into effect. It is for the offeror to prescribe the manner of acceptance. However, the avoidance of the offer cannot be made subject to the performance of a positive act by the offeree. Thus, the offeror is not allowed to force a contract to come into existence. For example, imagine X writes an email to Y saying, "I offer you my Ford car for sale. If I do not hear from you within 10 days, I will presume that you have accepted the contract." Will Y be bound by the contract with X if he does not contact X in the prescribed 10-day period? The answer is that he will not be bound. X has no right to force a contract on Y and make Y perform an act in order to avoid the contract's formation. Thus, Y may ignore such an email without incurring any legal liability towards X. If the offeree Y seeks to modify the terms of the offer made by X, he is said to have made a counteroffer, which will bring X's original offer to an end. A request for information by Y, however, seeking to clarify the offer that has been made by X, but not seeking to change the terms of that offer, is not considered to be a counteroffer and thus does not bring X's offer to an end. Now let's look at the requirement of consideration. Consideration is the exchange of value or benefit that each party gives the other in return for their respective promises under the contract. Frequently, the consideration people offer is money, but it can be anything on which a value can be placed. If consideration is only flowing from one of the parties and not from the other, then the courts will consider that the offer is a gift and they will refuse to enforce the contract. Without an exchange of consideration from both parties, an agreement is not considered to be a binding contract. However, once the existence of consideration between both parties is established, it is a general rule of the courts not to concern themselves as to whether the consideration given by either party is adequate. People are free to do business on the terms of their own choosing. Thus, if A wants to sell B his convertible Rolls-Royce for a reduced price of €5,000, the common law courts will not prevent the contract from coming into effect. The €5,000 offered by B will be considered sufficient consideration to enforce the contract. Thus, the law requires the existence of consideration, but it is not inclined to consider whether it represents good value. The common law rule requiring the existence of consideration has been slightly modified by the court's ruling in equity. Under the equitable doctrine of promissory estoppel, an offer made by X to Y may, and only may, as equity is a discretionary remedy, be enforceable by Y even where Y fails to provide consideration if X clearly appeared willing to be bound by his promise and it would be unfair to find otherwise. Now let's look at the final requirement, an intention to create legal relations. Finally, in order for a contract to come into effect between the parties, the courts require that the parties demonstrate that when entering the agreement, they had an intention to create legal relations. If there is a dispute between the parties as to whether this intention existed, the courts will look to the 1. Context of the agreement, for example, whether it was a business agreement or just an agreement between friends, and 2. The subject matter of the agreement, i.e. the content of the agreement, for example, whether it is an agreement to meet for a drink or an agreement to guarantee a loan. Moreover, there is a rebuttable presumption of an intention to create legal relations as regards agreements of a commercial character. In the case of domestic agreements, for example, an agreement between a husband and wife, there is a corresponding rebuttable presumption of no such intention. Can everyone enter into a contract? The answer is no. Only parties possessing the necessary capacity are able to enter into contracts. In most jurisdictions, only people over the age of 18 and in sound mental health are taught to have the necessary capacity to enter into a contract. Companies having a recognized separate legal personality are also considered as having capacity and thus may enter into contracts in their own name. Minors and mentally ill are not normally taught to have the necessary capacity to enter into an agreement, as the law considers that they do not have sufficient understanding to appreciate the consequences of their acts. Now let's look at the issue of implied contracts. An implied contract is a contract that is deemed to exist by the courts even though the parties did not expressly agree to it. There are two types of implied contract: contracts implied by fact and contract implied by law. Contract implied by fact are contracts that result from the behavior of the parties. For example, where the parties continue to perform a fixed-term contract that has actually come to an end, the courts would probably imply a contract to exist between the parties based on the fact of their continued performance. There are also contracts implied by law. A contract implied by law, also known as a quasi or quasi-contract, is implied to exist because the courts consider it to be appropriate. For example, a contract may be implied to exist as a means of preventing unjust enrichment by one party over another. Are there any restrictions on the subject matter of a contract? Well, in most common law countries, the parties to a contract are free to make any agreement they wish between them, as long as the subject matter of the contract is not illegal. If X agrees to pay €100 to Y under the table, in return for Y painting his or her house, the contract will be considered illegal as an attempt to defraud the tax authorities. As a result, despite having painted the house for X, Y will not be able to sue X for payment for the work done, as the agreement will be thought to be illegal and thus will have no existence in the eyes of the law. We hope you enjoyed this introduction to common law, contract law.